Go ahead. While
Okay.
I start sharing my screen, let me just remind everyone that we are recording this, so you will be able to access the recording. We will share the presentation as well. And if for some reason you don't get the email with the link to the presentation, you can always go to our website, click on the calendar of events, and later on this afternoon, the materials will be available on when you click on the calendar events for today. The other reminder is that please, if you have questions, use the Q&A function so that I can track the questions and answer them as I finish the more prepared slides. If you put them in the chat, it's harder for us to keep track of them. So please use the Q&A functions if you have any questions. All right, let me get to the actual slides.
We can see your screen, Erin.
Terrific. And we'll get started. So my name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority. I'm an attorney who's been practicing for over 20 years, 15 of which for the state of Connecticut. And several years before that, I worked in private practice doing employment law. So I've spent a lot of my professional life working on family medical leave related issues. So during our time together, we're going to talk a little bit about the Connecticut Paid Leave Program, just so everyone knows sort of who we are and what we do. And then we'll focus on understanding the laws, both FMLA and the Connecticut Paid Leave, so that we can leave here today understanding that they are different laws with different purposes. And then we'll talk about how both these laws will be implemented in terms of Connecticut Paid Leave Act and your employees coming to the Paid Leave Authority to apply for income replacement benefits, and FMLA, which is when employees go to you, their employers, for job protected leave. I'll share with you some additional resources, and as I mentioned, I'll make sure to keep time to go through any questions you submit through the question and answer function. But first, let's talk about the Paid Leave Authority. We're a quasi-public agency, which means that we have we're a political subdivision of the state with the legislative charge or the statutory mandate to provide access to eligible employees for paid leave benefits. So they receive income replacement benefits if they have to be out of work for specific covered reasons. Our role is also to make sure that employers, administrators, and healthcare providers understand the law and understand their responsibilities in connection with the Connecticut Paid Leave Act so that it works as a seamless whole. So to that end, we do engage in a great deal of outreach and education between webinars, videos on YouTube, going to events as much as possible, and making sure that we're providing much education and resources as we can. We're brand new, so we've really had to stand up, not just sort of figure out the policies related to the Paid Leave Act, but actually even our own employment policies. So as a brand new agency, we just had to kind of get up and running. So that's something we work on as a quasi-public agency. We issue policies after a 30-day public notice period instead of doing regulations. As we'll talk about, half of our responsibility relates to receiving contributions. And so we've been working on that, and we've been receiving contributions since January. Employers have an option of offering their employees an alternative to our program. So instead of having their employees receive benefits from us, employers can apply to us for approval to offer a private insurance plan or a self-insured plan. And so we've been working through all the requirements for that and approving applications for private plans. And starting in just about 6 weeks, we'll start receiving claims for paid leave benefits. We won't actually issue any benefit checks until January. That's under the statute. But we are going to start receiving claims in December to try to smooth out that opening quarter. So just a sort of a visual depiction of all the things we've been doing for the past year. Our website's been live for just over a year, and employer registration started last November. We have over 120,000 employers registered with us. And as I mentioned, employers were responsible for deducting the employee contributions starting in January. So we've been receiving those contributions on a quarterly basis. And as I said, starting in December, we will start accepting claims for benefits and we'll start issuing payments in January. All right, let's just threshold question here. Who's covered by this program? The short answer is almost everybody working in Connecticut. Technically, employers with one or more employees working in Connecticut are covered unless they're explicitly excluded by the statute or exempted through other laws. So covered employers include nonprofits. So even if you don't pay into the Unemployment Insurance Compensation Fund, you're still a covered employer. If you are a private sector employer with a unionized workforce, you're still covered. Sole proprietors and self-employed individuals are not required to participate, but they can choose to opt in for themselves if they want to. Just a note here, you're a sole proprietor who owns your own business, but also has employees. You do have to register and your employees would be covered, and then you could choose to opt in for yourself. If you do opt in, you have to stay with the plan for at least 3 years. There are some entities that are excluded by statute from the program, and that includes the federal government, the state of Connecticut, except as to covered public employees, municipalities and local or regional boards of education, unless they have covered public employees, and non-public elementary and secondary schools. Basically, these are the same entities that do not receive Connecticut FMLA either. There's a couple of exceptions, which I'll describe. There are some other statutes which exclude people from our program. And for example, there's a statute that says railroad workers are covered by federal railroad employee sick leave policies, so they don't participate in our program. Similarly, one state cannot impose mandates on another state, so employees who are working for the governments of other states are not part of our program. Similarly, we can't impose mandates on the sovereign nations, so people who are working for the Mashantucket or Mohegan tribes are not covered by our program. There's two little tweaky ones that I just want to take a moment to flag. If your business is engaged in interstate commerce, so think about interstate trucking, for example, and you have an employee who works here in Connecticut but lives in another state, they're not paying income tax into Connecticut. You're not paying payroll taxes in Connecticut for them, and they would not be participating in the Connecticut Paid Leave program. Again, this is just that simple small little exemption for those interstate workers who don't live here. Another small exception is for spouses of active duty military members who have opted to continue paying taxes in their home state instead of paying taxes where they're currently deployed. So if you have an employee who is a spouse of a military member, say they're at Groton, and they've opted to pay their home state taxes, they're not paying any income or payroll taxes to Connecticut, they wouldn't pay here. Other than those exceptions, as I said, most everybody else is covered. I promised you a definition for covered public employees. So that means the non-unionized employees of the state of Connecticut, managers, legislators, appointed officials, judges, we're all in, so we all contribute. Unionized employees of the state of Connecticut can collectively bargain to be included, and if so, they'll become covered. Right now, employees of municipalities and local or regional boards of education are excluded. So they don't remit contributions and they can't apply for benefits. However, if they're unionized employees collectively bargain to be included, then everybody, union and non-union, will come in. One more bits of pieces of information about sole props and independent contractors. As I mentioned, they don't have to participate, but if they choose to, they can enroll. When we're defining a sole proprietor or independent contractor, we're really looking at the way they categorize their earnings for purposes of taxes. So if you pay self-employment taxes, then we're going to consider you to be self-employed. If you want to enroll, you can enroll, and you would make your contributions based on a 0.5% of your self-employment earnings. If you receive a W-2, you're considered an employee. You've basically categorized yourself as an employee for purposes of the federal and state taxes, and so you'd be considered an employee for Connecticut Paid Leave. This is true even if you're also an owner or officer of the company. Okay, so really, If you pay self-employment taxes, that's what we look at to determine if you're a sole prop. If you pay income taxes pursuant to a W-2, we're considering you to be an employee because that's the way you've categorized yourself for purposes of state and federal taxes. So I've mentioned the contributions. Our program is entirely employee funded, so employees contribute 0.5% of their wages. We calculate the wages the same way you calculate the wages for purposes of FICA. And that's because under the statute, contributions are capped at the Social Security contribution limit. So we have to use the FICA number so we can make sure we're hitting that cap. It's the employee's money, but the employer is responsible for the paychecks. So the employer is responsible for taking the deductions out of the paychecks and remitting them to us on a quarterly basis with some really minimal wage information that we receive. The money gets deposited into a paid leave trust, which is actually administered by the Office of the State Treasurer. This paid leave trust can only be used to fund the benefits and administer the program. It is not considered state money and cannot be used for any other purposes. Okay, so that's a little bit about the program. Just look and see. We want to talk now about what are the words I'm using. What is FMLA? What is CTPL? Every industry has its acronyms and state government is no different. So FMLA, the letters stand for Family and Medical Leave Act. Technically, there are two different FMLAs that we should be concerned about. There's the federal FMLA and the Connecticut FMLA, so the Connecticut state law. Both the federal law and the Connecticut FMLA allow eligible employees to take job-protected time away from work. And both laws say that the leave is unpaid, but that the employer may adopt policies to provide income replacement during leave, either by having your own self-funded short-term disability or purchasing an insurance, or by having some sick leave policies or having your employees use their accruals. Connecticut FMLA is going to be changing effective January 1st, 2022. In several ways, including eligibility, including how much time they get, and including the reasons for leave. So let's get into that a little bit, just so everyone is prepared for this really big change in 2022. Right now, Connecticut FMLA, which has been on the books since the 90s, applies to employers with 75 or more employees. And an employee could get 16 weeks of leave in a 24-month period if they're eligible. And to be eligible, they have to have worked for the employer for at least 12 months. Non-consecutive is fine. And they have to show that they worked at least 1,000 hours during the 12 months immediately preceding the leave. All that's changing in just over 2 months. As of January 1st, Connecticut FMLA will apply to employers with 1 or more employees. There will no longer be an hours worked requirement for an employee to be eligible. Instead, an employee could receive job-protected leave after 3 months. The amount of leave changes to 12 weeks in a 12-month period. Now, there's something called military caregiver leave, which I'll describe in a minute, and you can get 26 weeks of leave for that. There's also a change which says an individual who's experiencing incapacitation during pregnancy could get extra 2 weeks of leave, so they could get up to 14 weeks of leave. There's one other change between the old FMLA and the new Connecticut FMLA, and that relates to the employer's ability to require their employees to use their accruals. As I mentioned, both federal FMLA and Connecticut FMLA says that the employer can permit or require an employee to use paid time off while taking FMLA leave. Under the current FMLA, an employer could actually require the employee to exhaust all of their accruals. Under the new law, the employer cannot require the employee to exhaust all of their accruals while they're out on FMLA. They'd have to let them hold on to at least 2 weeks of accrued PTO so that they could use those for some other purpose. So it's FMLA. Let's talk about CTPL. That stands for Connecticut Paid Leave. We actually use it to refer to the statute, which is the Connecticut Paid Leave Act, 31-49E of the Connecticut General Statutes. We also refer to it, we use CTPL to refer to the program as well as the authority. Basically, the Connecticut Paid Leave Act is that law that I mentioned that creates a source of income replacement benefits for eligible employees who cannot work. It does not provide for any job-protected leave. You might hear people talk about PFML or paid family medical leave. It means the same thing. We just like talking about CTPL because we think it's less confusing. It's less likely to get people mixed up between FMLA and CTPL. For both FMLA and CTPL, so for both job protected leave and income replacement, the reasons are the same. You can take leave and get benefits if you need to take time off from work to recover from or have treatment for your own serious health condition. You can also take time off to care for a family member who has a serious health condition. This is called caregiver leave. There's also bonding leave. This is the happy one. This is when you have a new member to the family, either through childbirth, adoption, or foster care. And you can take time off from work to bond with that new family member. For adoption and foster care, it's also considered bonding leave if they need to take time off for certain pre-placement activities like going to court or going to meetings at the foster agency. As I mentioned, there's military caregiver leave. This is leave to care for a family member who's been injured on active duty in the military. And then there's also something called qualifying exigency leave, which is leave if your parent, spouse, or child is deployed overseas. And there's specific reasons that you can take qualifying exigency leave associated with your parent, spouse, or child's deployment. Finally, there's a separate statute in Connecticut law called the Family Violence Leave Act. And this allows an employee to take time off from work to go to court, to relocate, or to receive treatment or counseling if they're experiencing family violence. And under the Connecticut Paid Leave Act, an employee can receive income replacement for those days. There are a couple of nuances to the caregiver leave that I want to flag for you. First, I should have said that all those reasons I mentioned, except for family violence, so medical leave, caregiver leave, qualifying exigency leave, military caregiver leave, are also available under federal FMLA. The difference between federal FMLA caregiver leave and the Connecticut laws are who is considered to be family for purposes of taking time off to care for them. Under federal FMLA, you can take time off for your parent, spouse, or child under 18, or someone who's 18 and over, a child who's 18 and over, who has a disability as defined by the ADA, which prevents them from engaging in 3 or more activities of daily living. So it's a kind of a small unit of family. Under both Connecticut FMLA and Connecticut Paid Leave Act, an employee can take leave and receive benefits for other members of their family, including a son or daughter of any age, a sibling, a grandparent, or a grandchild, or an individual who's related to the employee by blood or affinity, whose association to the employee is the equivalent of one of those family relationships. All right, now what does that mean? Well, basically it's a recognition that families come in all shapes and sizes, and you could have a family relationship with someone even if you're not related to them by blood or marriage. So think about the aunt or the great aunt who really stood in the place of your grandparent in your life. They attended every school event, every game, every occasion. You took care of them. When they were older, you were the one who's going to be taking care of them when they're sick. That could be considered the equivalent of a parent or a grandparent, and therefore it would be an affinity relationship. Another example could be unmarried couples. Connecticut does not recognize common law marriage. So people who are in a committed spouse-like relationship who have not actually gotten married are not considered married under Connecticut law, but it's an affinity relationship equivalent to marriage that would now be covered. So again, the question is if it's paid leave versus FMLA. And so I just want to reiterate, FMLA gives you job protected time off from work, and CT paid leave gives you income replacement if you're out of work. So the reasons that you can receive income replacement under Connecticut paid leave are all the same reasons that you could take job protected time off from work under Connecticut FMLA. Let's see if I can get this moving. Quick summary of the eligibility requirements, because even though the reasons for leave under Connecticut FMLA and the reasons to receive income replacement under Connecticut paid leave are the same, the eligibility requirements are different, and they're different again as compared to federal FMLA. Start with federal FMLA first, since that's the one that's not changing and may be familiar with you. Federal FMLA applies to employers with 50 or more employees. And to be eligible for job protected leave, the employee has to work for the employer for at least 12 months and work for at least 1,250 hours in the 12 months immediately preceding leave. So this is similar to, not exact, but similar to the old Connecticut FMLA eligibility. But as of January 1st, Connecticut FMLA eligibility will change to only requiring the employee to be working for the employer for 3 months. For Connecticut paid leave benefits, for the income replacement benefits, we don't look at how long you've been employed by any particular employer. We're looking at how much money you've earned while working in Connecticut. If you've earned at least $2,325 in your highest earning quarter, when we look at the first 4 of the 5 most recently completed quarters, you'll be eligible. We have access to data from DOL, as well as, if necessary, data from the employees. So we'll be able to determine the 2325, and it may come from more than one employer. The other part of the eligibility test is that the applicant has to show that they're either currently working in Connecticut for a covered employer, or if they're not, that they had been working for a covered employer in Connecticut during the 12 weeks, at some point in the 12 weeks before they apply to us. So a recently unemployed person could still get benefits from the authority, or you could be an enrolled sole prop. Another just quick summary. FMLA is 12 weeks in a 12-month period, with that 26 weeks for caregiver leave. Connecticut FMLA is also 12 weeks in a 12-month period, with the ability to take 26 weeks for caregiver leave, military caregiver leave. Those 12 days that I mentioned for family violence leave, and 2 additional weeks for incapacity during pregnancy. So an employee could get up to 3 months of job protected leave. And under Connecticut Paid Leave Act, they could get income replacement for those 12 weeks. We only provide the 12 weeks, even if it's military caregiver leave. The 2 exceptions are that for family violence leave, we only provide income replacement for those 12 days that are covered under the Family Violence Leave Act. But we do provide 2 additional weeks of income replacement if the employee is out for those 2 additional weeks associated with incapacity during pregnancy. So let's talk a little bit about the implementation, because I'm seeing a lot of questions coming in about implementation. First, I think it's always easiest to think about roles and responsibilities. So in connection with the Connecticut paid leave contributions, we've got the worker, the employer, the authority, and DOL. The worker is responsible for contributing the money. It's their money. They contribute 0.5%. The employer, who handles the payroll, is responsible for deducting that 0.5% and remitting it to the paid leave authority. And the way they do that is through their CT paid leave account that they've registered with on our website. Or if they have a payroll provider, the payroll provider's remitting it for them. Even if you have a payroll provider, we still want every employer to have their own CT paid leave account because it'll simplify life when we get to the claim side. The paid leave authority receives those contributions and puts them into the trust. We process any over or underpayments, and starting next year, we will start imposing penalties for non-compliance. We haven't done that this year. So this is new for everybody, but penalties for non-compliance will begin next year. The Connecticut Department of Labor does not have an official role in connection with the contributions, but they do have a general role associated with their wage and hour authority. And they can use that authority to allow employers to take deductions from employees' paychecks that are separate and apart from the deductions established by statute. And so they've used that authority to allow employers to take catch-up deductions through the end of the 3rd quarter of 2021. That catch-up period has ended, and so employers who did not take employee deductions starting in January, who have not yet sort of caught up with those mandatory deductions may want to talk to DOL about getting permission to take additional deductions to try and get caught up. Or the employer can just cover the costs and work with their tax advisors to deal with the tax implications of the employer paying for something that's technically the employee's responsibility. On the claim side, the worker is responsible for submitting the application to the Paid Leave Authority. They can do that by calling. We have entered into a contract with AFLAC as our third-party administrator, so they can call AFLAC, or they can email, use US mail, or do it online. And they can, when they do that, they'll create an account with CTPL Leave Authority, which will connect them to AFLAC, and they'll complete their application, provide documentation, and provide us with information about their absences and any additional information, any additional sources of income that they're receiving. Workers are also required by law to notify their employer if they're applying to CTPL leave for benefits. The employer's role with regard to CTPL leave benefits is relatively small. Basically, we need you to complete and submit an employment verification form. We'll be giving that form to your employees. The employees will give it to you, and then you'll send it back to us. We may need you to validate absences or other sources of income on an as-needed basis. And because your worker and we need to know if you're going to be requiring the employee to use their paid time off, you need to decide, are you going to require your employees to use their paid time off? Do you have a paid time off policy? Do you have short-term or long-term disability insurance that they need to pay attention to? So you need to know what you have and tell your employees. And as always, you have to refrain from discriminating or retaliating against a worker who's told you they're applying to us for benefits. The CTPL Leave Authority with our contractor, AFLAC, will determine eligibility for benefits, will review the documentation provided, and approve or deny. We'll calculate the benefits, we'll monitor the ongoing relationship. If we deny benefits, there is an opportunity for reconsideration internally before they go to an appeal. We will investigate fraud and impose penalties for fraud. And the Connecticut Department of Labor is responsible for hearing appeals relating to our denial of claims or if we impose penalties. So what does this look like on a step-by-step basis? Well, again, worker submits the claim. So they call AFLAC or go to ctpleave.org and hit the submit a claim button, give us the documentation, explain to us, I'm going to be out of work for 3 weeks for caregiver leave. It's going to be a block, which means one period of leave, extended period of time. And I don't have any paid time off from my employer. FLAC will determine eligibility utilizing data from DOL. Will validate that they're working for a covered employer or otherwise enrolled. If the employee is not eligible, we'll notify them. If they are eligible, we'll review the documentation, like the med cert or other documentation we need, let the worker know if there's anything missing, and either approve or deny the claim. When we approve the claim, we will notify the employer the claim is being approved, and we'll also let the employer know the length of time and the hourly rate for the benefits. The hourly rate is based on the statutory calculations using data from DOL and other sources of information about the employees' wages and other paid time off or other offsets. And then we'll issue the benefits. We'll be issuing benefits either through electronic transfer or a stored value card, basically a debit card. The plan is to issue benefits each Tuesday. So the benefits will be paid on a weekly basis on Tuesdays, basically 10 days in arrears. So for that first week of January, for someone who's approved for the week of January 2nd through January 8th, the benefits will be paid on the 18th. This gives us time to make sure that we receive the information and take into consideration any offsets and to validate that the employee is actually out of work. We won't pay for time when they're actually working. Employees are required to notify us of any changes to their status, including length of leave, other income, and employees who take intermittent leave, which is several absences, usually of a short duration, all associated with the same leave reason. think having to go to physical therapy, or being a person who has migraines or Crohn's disease, where you have flare-ups, and so you're out for these sort of discrete periods of time, all connected to the same reason, they'll have to let us know those absences because they're not necessarily foreseeable. As I mentioned, the calculations are based on the statutory formula. A worker who earns less than or equal to the minimum wage times 40 will receive 95% of their base weekly earnings. And that's based on their highest 2 earning quarters when we look at the first 4 of the most 5 recently completed quarters. If someone's base weekly earnings are more than the minimum wage times 40, they'll get that 95% of 40 times the minimum wage, plus 60% of the difference between what they're earning and the Connecticut minimum wage times 40. However, in all circumstances, the total benefit is capped at 60 times the Connecticut minimum wage. So just like contributions are capped, so too are the benefits. So just a way of example, someone who's earning $13 an hour with no offsets would be expected to receive $494 in benefits. Someone who earns more than that, we're now kicking into that 60% of the difference. And so someone earning $13.50 an hour might receive $506 a week in benefits. I know I received a couple of questions in the Q&A about interaction between time off and employer-provided benefits. So statutes don't give us a lot of detailed information, but they do say 2 things. First, they say that an employee can receive employer-provided benefits and Connecticut paid leave benefits at the same time, provided the total amount does not exceed 100% of their regular wages. And it also says that the employer may require or permit a worker to use their sick time or other accruals or other paid time off. But they have to hold on to those 2 weeks. You can't make them exhaust it. Then we also know that lots of employers offer short-term disability insurance. And so with regard to short-term disability insurance, you really need to look at the policy itself. Most policies say that they're the payer of last resort, meaning that you have to use the employer benefits and the state benefits before you even tap into them. So they're usually at the back end. So there are 4 opportunities or 4 different categories. First, a worker does not have any employer-provided PTO. They don't get it, or they've used it all before they've gone out on leave for other reasons. So in that situation, their leave would start on, Monday, January 2nd, and they'd start receiving benefits as of Monday, January 2nd, so that there'd be no gap between the leave and the benefits. On the other hand, you may have an employee who does have sick time on the books, and the employer says, we want you to use the sick time we're providing to you. If that PTO is equal to their regular pay for the full amount of time that the worker would want to be out on leave, then they're just going to use that employer-provided PTO, and they won't tap into the CT paid leave benefits at all. Their 12 weeks of CT paid leave benefits aren't touched and remain whole if they need it for another reason. Again, sort of the safety net idea. Then you have situations where maybe an employee only has a week's worth of employer-provided paid time off, but they need 3 weeks of leave. Well, if that PTO covers their regular pay, but only for 1 week, then their leave would start, say, on January 2nd, but they wouldn't start receiving paid leave from the authority until the following week. So we'd be sort of off cycle for a week. The other category is where the worker receives employer-provided paid time off, but it's less than the equivalent of a full day. So maybe the policy is that the employer pays 50% of their salary for a day. So the employee could start on January 2nd and receive benefits from the authority and benefits from the employer at the same time. And we just need to know that how much they're getting so that we don't exceed the 100%. And that's why we ask for that information on that employment verification form. Basically, we call this a tip for workers, but it's important for employers to know too. Workers need to know if the employer will require or permit them to use their employer-provided PTO, and if there are any rules. Some employers say you can only use sick leave for their own serious health condition, but not for caregiver leave or bonding leave. And finally, you need to know if you have a short-term disability policy, what it says, and if it says that you're a payer of last, it's a payer of last resort. So that's the Connecticut Paid Leave Act. That's about the money. So there are a couple of specific questions, but I'll get to FMLA first, and then we'll go to the questions, just because I think it's helpful to understand the differences between Connecticut Paid Leave and Connecticut FMLA. The first difference is Connecticut FMLA provides for job-protected leave. It doesn't have to have money at all. The second difference is that the relationship and the work is really between the worker and the employer. Paid Leave Authority has no official responsibilities relating to FMLA, although we do talk about it because it's really hard to provide training on paid leave without talking about FMLA. So the worker has to notify the employer that they need time away from work. They don't have to say it's FMLA. They may not know that word or that phrase, but they have to give you enough information so that you, the employer, can understand, this sounds like a serious health condition or a caregiver situation. This sounds like it might be FMLA. If you require your employees to submit an application, the employee has to submit an application. And if you require the employee to provide supporting documentation like a medical certificate, then they have to do that. And if you have attendance policies or call-in policies, they have to comply with those. So it's up to you. Do you want to have an attendance policy? It's a good idea. If you don't, you should have one. Do you have call-in policies? What are your PTO rules? There are some requirements about FMLA postings that are subject to federal FMLA and state FMLA. If you're large enough for federal FMLA, you can go to the you can go to the US DOL at www.dol.gov, and you can get that information there. As the employer, it's your responsibility to process your employees' leave requests and monitor their leave usage, as well as managing their employees' return to work. And of course, don't discriminate or retaliate because they're utilizing their statutory entitlements. The Connecticut Department of Labor is responsible for administering the Connecticut FMLA, so they are working on updated regulations, as well as other guidance for workers and employers. And they will investigate complaints about denials of FMLA, as well as discrimination or retaliation complaints. So, as I mentioned, the process starts with the worker telling the employer they need time off from work. They should do this at least 30 days in advance if the need for leave is foreseeable. The leave is not always foreseeable, and so they have to tell you as soon as practicable if that's the situation. As the employer, you determine if they're eligible for Connecticut FMLA. Have they worked for you for 3 months? You also need to think about if they're eligible for federal FMLA, if you're covered by that or other laws. And you have to tell the employee if they have to provide you with additional documents. You have 5 business days from knowing about the need for leave to notify the worker if they're eligible and to provide them with something called a Notice of Rights and Responsibilities. The Connecticut DOL is working on a sample Notice of Rights and Responsibilities for employers to use. This is not leave approval. This is just, yep, you've got 3 months in, so at least it's possible for you to have leave. You tell the employee, I need a MedCert, I need to see the adoption documents or whatever it is. They have 15 calendar days to provide that to you. But if they're having trouble getting you the documentation within 15 calendar days, you are required to give them more time, usually 15 more days, but that's not in the statute. Once you've received a complete and sufficient certification, you have to notify them if they're approved or denied. And you have 5 business days from when you've received the complete and sufficient documentation. And when you notify them if they're approved or denied, you also have to make sure you're clear, put it in writing about the use of paid leave accruals, if you need them to report in, if they need a fitness for duty, if they're out for their own serious health condition. If the need for leave is foreseeable and this has all happened in advance, that's great. You'll see that a lot with the pregnancy situations. Then they need to call you up and say, okay, I'm in labor. I'm really going to start taking my FMLA now. And you'll track their leave. Because an employee might be eligible for federal FMLA and Connecticut FMLA, you want to track both if you're covered by both laws. Then this whole name of the game for FMLA is job protection. You have to return the worker to the job they had before they went out on leave. The same job with the same terms and conditions. You can't turn a first shift worker into a third shift worker just because they took FMLA. Similarly, you can't say the employee has to be 100% fit for duty or totally recovered before they come back. You can say that the doctor has to sign off on them coming back to work, but you have to consider whether the employee has any rights under the Americans with Disabilities Act or the Connecticut Fair Employment Practices Act to accommodations that would enable them to perform the essential functions of their job. Right. Well, FMLA is not the easiest thing in the whole wide world. We know that. That's why we spend time talking about it. In my experience, the single best thing you can do to understand FMLA and to make sure your employees are getting what they're entitled to, but not more, is to have a good attendance policy that you enforce. Have a call-in policy and make sure that your supervisors tell your HR or operations person when the employees are out so that you can start the FMLA process and you know what's going on. Second most important thing, particularly for medical leave or caregiver leave, get a good med cert. Don't accept a scrawl on a piece of paper. Connecticut DOL, federal DOL, and the Paid Leave Authority all have sample med certs. You can use any one of those. Intermittent leave, as you mentioned, could be difficult to manage because sometimes the absences are unforeseen, but you want to make sure you're tracking the time. You want to make sure that you and the employee understand that their absences are counting against it. If you have workers who work a fluctuating work week, particularly overtime, you need to account for that overtime when you're thinking about what their average work week is for their entitlement. And if they can't work overtime because of their FMLA condition, you would draw that time against their entitlement. As you mentioned, you've got Connecticut FMLA, federal FMLA, you've got the ADA, Connecticut Fair Employment Practices Act, workers' comp, pregnancy. You have to kind of keep all of these in your head when you're thinking about an employee being out, because you can't say, oh, well, I gave you FMLA, but I didn't give you any consideration under ADA. You need to know about this. There is some good news. An employee can't just say, oh no, don't call this FMLA. I want to save my FMLA time for later. In all circumstances, it's the employer's right and responsibility to designate time off that qualifies under FMLA as FMLA. So this is a way to make sure that you're giving them the entitlement the amount of time they're entitled to, without having them stack different leave entitlements one on top of each other, or say, oh, I'll use my sick leave, but I don't want it to be called FMLA because I want to use my FMLA later. Because then they're going to be out for longer than they're entitled to, which adds to the difficulty managing. So, quick slide, mostly just to give you kind of a quick visual of other laws to pay attention to, and to make sure, for me, I don't forget to tell you something, including workers' comp. If an employee is receiving workers' compensation benefits, they cannot receive benefits from the Paid Leave Authority. So that's an automatic either or. An employee who is out on workers' comp has their own entitlements. So before I get to the questions that I see coming in, let me just show you that if you go to the ConnecticutPaidLeave.org, CTPPaidLeave.org, we have a lot of information. We have a whole page for small businesses. We have a page that talks about preparing for claims process. We have employer toolkits. We have HR toolkits. We have posters, mailers, fact sheets, videos. We also have videos on YouTube if you want to check those out. And if you still have questions that aren't answered in our frequently asked questions or on our videos, you can contact us using our Contact Us portal. It's a button on ctpaidleave.org. Just submit your question, indicate to us if you want a call back or an email back, and we will work with you to make sure you have answers to your questions. We do not have, quite frankly, the funds to support a call center, so we do not have a number for you to call us up to ask your questions. at this time. But if you submit your question through Contact Us, you'll get a response back. And as I said, if you want to call, we will coordinate a call back for you. All right, ctpleave.org. Make it a favorite. Make it something you check back. We're updating it pretty regularly. We've got a lot of new content on it as we ramp up for the new claims process. So can you just leave that on there for a moment? You kind of remember it and make sure that it is a favorite for you. Okay, questions coming in. Is there a CTFMLA poster available online? Not yet. Department of Labor is still working on their updated regulations. And so that is something that you can check back on ct.gov/DOL to check to see. A couple of questions have come in about people who are pregnant or have employees who are pregnant and who are due in December. They want to know, can I take leave in January? And can I get income replacement money in January? The answer is yes. So even if the reason for leave, in particular pregnancy, actually starts before January 1st, as long as you're still out of work, then you can be entitled to benefits starting in January. We do not give money for people who are out of work in December, but if they're still out of work, they can apply and start getting those benefits in January. Question about documentation for pregnancy. So if a person is out of work while they're pregnant, they do need to provide a med cert to us, and most employers do require that as well for the FMLA side. If they're out of work for what's called the disability period after childbirth, so the person who gave birth is still recovering from the childbirth, you need a med cert for that. If they're out of work to bond with the baby, it's not a med cert, but we do need documentation to validate the birth of the baby. So that might be a hospital record or a birth certificate or something like that. For purposes of the Connecticut Paid Leave Authority, we have information about our documentation on our website, and it's also provided when people apply. It's in there, it's all detailed. Question about federal FMLA and Connecticut FMLA running concurrently. Yes, they may. So if an employer is subject to both, so they have 50 or more employees, so they're subject to federal FMLA, and at least one employee working in Connecticut, so they're subject to Connecticut FMLA, and the employee is eligible for both, and the reason for leave is covered by both, the leaves will run concurrently. So that's 3 ifs there. Say you're covered by FMLA, federal and state, but the employee's only worked for you for 6 months. They're not eligible for federal FMLA, so they're not going to tap into that entitlement, but their Connecticut FMLA would run. So you need to assess each entitlement separately. Okay, just double check and make sure I haven't skipped any. If an employer provides paid time off and the employee has an absence covered by both paid time off and CTPL, are we required to allow the employees the choice of whether they want to use their employer PTO or CTPL? Or can we ask the employee to take the absence as CTPL? So you have the right to decide. Under Connecticut FMLA, you can decide whether to permit or allow your employees to use paid leave. To use their PTO. We will ask you what your policy is, but we cannot require you to require your employees to use employer-provided time first. It's for my dog. Still, after 1.5 years, still doesn't know when I'm on webinars. Similar question is, our company currently provides 100% sick time pay for employees. But in 2022, we want to revise our policy so that employees would apply to CTP leave first, and then the employer would supplement. So again, there's no statutory prohibition on that. That is something that the statute allows employers to do. A couple of things to be aware of. Our benefits are not based on the wages the employee is currently receiving from you. The paid leave benefits are based on the employee's highest earning 2 quarters when we look at the first 4 of the most 5 recently completed quarters. So an employee could have benefits based on the job they had before they started working for you. So that could result in some difference of treatment, right? You have an employee who's been working for you for 6 years, and an employee who's been working for you for a year. They currently work in the same job and they currently earn the same amount of money, but the one who's been working for you for a year had a different job, and so their benefit amount is different. And so if you're supplementing, you could be paying more for one versus the other. Just something to be aware of. We just need to know what you're doing so we can validate to make sure that the total doesn't exceed 100%. Okay, just double checking. Is there a fax number for the submission of forms? Because medical offices don't like to send things by email. So yes. So for our purposes, for CT paid leave, we will give the employee the medical documentation that they need to have their medical provider complete. A medical provider can submit that form to us electronically or by fax or by mail. We will also give the employee the employment verification form for the employer to complete, and the employer can submit that to us by fax, email, or mail. That employment verification form does ask for confirmation of the work schedule. We do need to know what their regular work schedule is, both for purposes of calculating what constitutes their work week. Again, if they have 2 jobs, we need to be able to get both to make sure that we're not paying them for time that they're actually working, and to help us if they're taking intermittent leave or the like. We need to know kind of what their regular schedule is so we know when they're not working. Question: if an employee has taken a 3-month company-provided maternity leave starting in October that concludes prior to January 1st, and then the employee returns to work, can the employee go back out for the same birth event as of 1/1 via CTPL leave? Okay. So if an employee say that they had the baby in October, they took their 12 weeks of, say they're eligible for federal FMLA, they're out. They've used up their federal FMLA. So they don't have any more right now. Depending on how you calculate your Connecticut FMLA, you have to look at the Department of Labor website to determine if they're entitled to any additional time under Connecticut FMLA. Connecticut FMLA is switching from a 16 weeks in a 24-month period to a 12 weeks in a 12-month period. So the Connecticut Department of Labor has issued a guidance on their website for employers to figure out how to deal with that. For Connecticut paid leave, we don't provide job protection. We just provide money. So an employee could say, I want to stop working and bond with my baby, because you can bond with the baby up until the year after the baby's born. I'm going to give up my job and I'm going to apply for Connecticut paid leave to receive income replacement benefits for 12 weeks. There's nothing in our statute that prevents an employee from doing that as long as they're eligible for a leave at the time they apply. But if they do that, getting benefits from us does not give them job protection. So they really need to weigh short-term gain versus losing their job. So for Connecticut FMLA, you want to look at the Connecticut DOL website to see how to adjust for the difference between the old entitlement period and the new entitlement period. Question: can an employee be out on federal, Connecticut, and CTP leave at the same time? Yes, they could have job protection under Connecticut FMLA and federal FMLA, and they could be receiving income replacement benefits from us all at the same time. It's like the happy, easy path. Or it might be a little bit off cycle because they're eligible for one but not the other, or because they're using employer-provided benefits first, which employers may choose to do so that the employee doesn't stack job protection under FMLA with job protection associated with their accruals and extend out their leaves. Okay, will your office inform employers how much of a pay benefit the employee will receive? When we approve the benefit, we will notify the employer that it's approved. That sort of whether it's a block leave, intermittent or reduced schedule, and the amount of time, and the hourly rate will pay. New question, will a copy of the CT MedCert form be available on our website? Yes, it will be available. It is not available yet. Frankly, we can't receive claims yet. So we're trying to make sure we don't put anything on our website that encourages people to submit claims that we can't receive yet. But we will be getting that up. And as I mentioned, federal DOL has a sample form, and it's my understanding that Connecticut DOL may be putting out a sample form as well. But from our website, you can look back next month. I would expect to see it next month. Is a private college considered a covered employer? Great question. Yes, it is. The exclusion for private schools is only for private elementary and secondary schools. Colleges are covered. Follow-up question about when we notify the hourly rate of pay, will we also inform how many hours they're approved? We're going to give you that general. The application is for 6 weeks. We'll say that. The application is for intermittent leave from January through May. So we do give that basic information. Again, this is employee funded and with no employer contribution, which does limit the amount of detailed information we're able to give to employers, but we will provide what we can to help facilitate the relationship. And we will notify the employer through the means that the employer tells us when the employer fills out that employment verification form. You know, email is usually the fastest way to communicate. So that's the kind of goal. But the employment verification form has space for the employer to tell us who and how to communicate with. All right. I saw that some people put information in the chat. I am not able to review those right now. Hopefully you carry them forward into the Q&A. So hopefully they're responsive. If you have additional questions that we were not able to get to during this hour, because we're just coming up on 1:28, as I said, please do go ahead and check out our website at ctpleave.org. Check out the information that we have online, check out the videos, and you feel free to submit questions through that contact us feature. If you've submitted a question through the contact us feature and haven't received an email back, check your spam folder. We do automatically acknowledge the question and we respond usually within 2 business days, if not less. So if you haven't heard from us, it might be because our response is getting caught in your spam folder. So do check that out. All right, I should stop the sharing. So hopefully ctpleave.org is burned in everybody's memory so that they will remember to check us out and make us a favorite. I hope that you all have a good afternoon on this has turned into a sunshiny day. And please check out our other webinars. We will have webinars dedicated to HR, to workers, and again, check out ctpleave.org. Thank you very much.